Well, we're back here. Get a grip on lighting, um, presented by the National Association of Innovative Lighting Distributors. Disclaimer on the previous slide. Greg, before we get to legal challenges or legal options for the DesignLights Consortium presented by David Radulescu of Radulescu LLP, he's a lawyer. He's one of the lighting industry's lawyer. How did you get here, Greg Eric?
How did I get here?
Yeah,
Where?
right here
I
now in
mean,
this spot.
this, on this podcast?
Yeah, like how did you get here? Legal challenges for design light. How did you get here, dude?
I don't know. I wonder that sometimes. I mean, I look back to, we met at a nail convention many years ago. We've had a lot of good discussions, and then the podcast started, whatever, 7 years ago, and it's kind of at the point of maybe this is what the podcast was meant to do: is call out what's wrong with lighting and figure out how to make things right.
Yeah, I don't enjoy this, Greg. This part
Yeah,
of it. We used to have fun, didn't we?
I thought so. That was the whole reason we did this. I thought.
Yeah. Like it used to be a lot of fun. And I've received like emails from people, and there's been some backstabbing and people making allegations against me. And ever since this started, Greg, it's been like it's gone from being a fun side hustle to being like a burden. Like a
Hmm.
very big burden. And I feel like I sell light bulbs, folks. Greg's a light bulb salesman.
All I'm trying to do here.
Yes, I'm a light bulb salesman. We're from a very, very small little boutique lighting association of guys and gals who sell light bulbs and light fixtures to the public. And, we don't have any kind of axe to grind here. We don't care. And I hate doing this, Greg. I wish it wasn't like this. Do you agree?
Totally, yeah. I'd much rather just be selling light bulbs and getting after it and having fun. But right now we're on more of a serious topic, and that's what we gotta. That's what we're getting a grip on. That's what the point of the podcast is, to get an understanding of all that's going on in lighting.
And so we have our old friend back to the show. I don't know if he's old, but he's like a medium old friend. We're going to be given a presentation by David Radulescu in a moment, but I want to tell you guys out there that this is a real David and Goliath battle. And Greg have stuck our necks out there really far here. And it's not comfortable. It's not comfortable for us. We don't like this. I don't want to be here. And you remember how that I purchased that horticultural lighting contractor about 2 years ago, Greg? Remember that?
Yeah, yep.
Now it's all about the DLC telling people how to grow food indoors. And it's
Do
like,
that too.
what the heck are you talking about? And it's like, no, dude, you don't know how to grow food. You know what I mean? Like, what's going
Yeah.
on here? So, anyway, we put out our podcast with our report, and I spoke to David Radulescu a little bit about it beforehand. And a lot of people they complain about lawyers, Greg. They say lawyers this, but you know what? David and I actually spent a lot of time speaking about what was best for the industry moving forward from this. And
Hmm.
he and I spoke about that. And I actually put a check mark in my little written book every time David mentioned something about what was best for the industry moving forward. David Radulescu, welcome to the Get a Grip on Lighting podcast.
Good afternoon, Michael and Greg. I'm
Hello.
not sure if I should be thanking you or or asking you for an apology. We'll find out after the show. But as you know, yeah, the last thing I really wanted to do is get dragged into the middle of a dispute, right?
Sure.
And I'm here as a friend to the industry. I'm here as a friend to you know charities,
Hmm.
right? Educational charities, IES to various consortiums. But I agreed to come on this because I feel like, I may have something to contribute, and I could do it from both perspectives. I could do it from the industry's perspective, and I have comments about that. And I could do it from the consortium's perspective. And that's what I'm here to do. Offer some guidance, offer some comments, to try to help move the important mission of, I think, the DLC forward. Right, it's an important mission in a number of areas. It's not limited to, LED lighting. As you know, there's the horticulture aspect of it. There's the Luna aspect of it. I think they're even getting involved in some EV stuff now. But I'm here to sort of offer comments. And as I said, I got about 30 slides that I spent, many days this week preparing on since I listened to your podcast last Friday night.
Okay. So go ahead. You want to go? What you're going to have to do is just call for the next slide when you're ready for it. Okay, David?
Sure. Okay, Scott, next slide, please. And before we get into the details of it, let me just frame, at least from my perspective, let's frame this debate, what it's about and why it matters, for those that may not be up to speed on it. But it's about access to energy rebate dollars. There's a lot of them. It's clearly over $1 billion, I think, per year still. It's about certification criteria either influencing or dictating the design of LED lights, right? It's about, should the DLC have the power to influence or dictate? At this point in the 15-year-old LED industry, and we could talk about the pros and cons of it, and I can do it from both sides, right? There's two perspectives. And then, most importantly, from the DLC's perspective, is why the industry, their industry trust is eroding. There appears to be some erosion, and I have comments to say, and I have suggestions to make. That's the table that we're living with. Scott, if you can go to the next slide. There's two sides to this debate, as I mentioned, right? It's the LED industry versus the DLC, and from the LED industry side, there's a perspective that they may want to dismantle the status quo, dismantle the DLC certification process, and force the DLC to revamp the way it's doing charity work, And if that's their perspective, one question to me is, what are the potential legal challenges to achieve that objective, right? There's legal challenges, and lawyers get involved with this. And we could talk about, and I'll spend half my time talking about these legal challenges from the industry side. And then halfway through, I'm flipping. I'm going to the next side. It's the DLC slide. And from their perspective, if they want to survive this industry outrage, right, or this industry backlash, whatever you want to call it, what do they need to do to earn back trust? And what do they need to do to move forward on their important mission? And those are the two sides to the coin. Before I dig in, lawyers always have disclaimers. And the good news is that on slide 4, I won't be reading these disclaimers as fast as you hear them on TV. I'm just going to go through them and just make clear what the purpose of my role today is. And just remember, the information that I'm presenting, it's being provided as a public service to the industry, right, to move the dialogue forward. I, as a lawyer, reserve my right to pick a side in this debate in the future, at a future time, to argue either against some or whatever I present today, or to argue for what I present today. And I'm reserving that right. I don't have a client at this point. I'm not representing any individual companies in this dispute, and I'm not representing the DLC at this point. That's the first disclaimer. The second one, I'm not intending to provide or offer any legal advice to the industry, to the DLC or its board today, right? So you gotta make sure you don't rely on this presentation for any action, right? Consult your own attorney if you want legal advice. And the last disclaimer is that there's no attorney-client relationship created with my firm or any of my lawyers, me in particular, until that type of relationship is established in writing. So those are the disclaimers. Let's go to one cautionary, and it's a last comment that I have. The question is, what did I do to prepare for today? What's the basis of my discussion? And I wanted to lay out, what I know about this dispute. And most of it has been gathered over the last week or so. I've obviously been aware of it for 1 to 2 years when NAILD put out their 2023 letter. But what did I do for today? I reviewed all of the nailed reports, their letters, setting the framework for the debate and controversy. And I reviewed whatever DLC responses there were. I think there were a few of them. Second, I actually spent 100 minutes going through your Get a Grip, on lighting podcast last Friday night. And then when I decided I'm going to dig deeper, I had to do it a second time. So I went through 200 minutes, Scott and Greg, of listening to you guys since last Friday night. I've also reviewed the press coverage. Randy Reed's Edison report and some of the older Inside Lighting discussing the controversy. And then last weekend, I downloaded over 80 filings. You could go onto the Massachusetts State Public Charities website. You can get the charity income tax return. That's called the 990. You can get the annual reports. You can get an independent auditor's report with the financial statements, and they're all there. 1997 to 2023, there's 80 plus filings of two entities. The initial Northeast Energy Efficiency Partnership, formed in 1997, and then they went through a name change in 2016 to Efficiency Forward Inc. And then there were two sets of organization and bylaws of this entity back in 1996, and then an amendment in 2017. And then I took all that stuff, I reviewed it, I analyzed it, in a time crunched manner. I didn't have a ton of time, but enough to be comfortable that I can come onto this show and hopefully offer some useful comments to, as I said, both sides. I'm going to try to stay in the middle of this dispute. I'll start with some background for specific purposes, okay? The DLC certification program is for obviously energy rebates. There's 370,000 products listed if you go on now. Half of them are standard certifications, the other half are premium. Half of the products out of the 370,000 are indoor, half are outdoor. There's about 800 manufacturers. And what's interesting, if you go to the next slide, Scott, is that 15 of the 800 manufacturers make up over 58% of the listed products, right? So this is a chart that shows who are the heavy users of the certification process. And what we see, of course, is Acuity having over 63,000 products listed, right? And then you got, Cooper Lighting, and then you got the others. But the point is that there's some big Goliaths that are spending a lot of money and time getting certification for their products. Let's go back one slide, Scott, because I wanted to compare, and I think it's important to compare the DLC to the Energy Star program. We all know about the EPA's or the DOE's Energy Star program that was sunsetted, right, as of last December 31st. They're done. You can't use the Energy Star on these LED lighting products anymore, right? They're done. And they went through an analysis over the last couple of years. I think it took them 2 years to go through that process where they put out a memo that they're giving the industry warning that they've decided to sunset. And they made this decision based upon a couple factors. One is market transformation. It's a mature market now. It's 15 years later. Their second point was everyone has LED lights. Everyone's using them. There's no need to further push them, through and provide incentives through at least the DOE Energy Stars to enhance purchasing. They also commented that the efficiency gains are plateauing. In other words, as you know, you got a 60-watt light bulb back in 2010. It'd be useful to be able to take it from 60 down to 5 watts. And that's what the Energy Star program and the DOE did, right? They promoted LED lighting to get rid of 55 watts per socket. Multiply it out by the number of sockets, it's a lot of energy. And they accomplished that, right? So now when these products are at 5 watts, right? Is it really, how beneficial is it going to be to knock them down to 4.5, to save a half a watt per socket. And they say the juice is not worth the squeeze.
Mm-hmm.
And my one joke that I'll give right now is the electrons are not worth the squeeze, right? So that's the DOE, and I think the DLC is going to have to, confront this, because they're, as you know, the EPA and the DOE is they're doing, for the most part, what they should be doing, and they've made a legitimate decision that there's no longer reasons that are compelling enough to continue. Next slide.
Before you
Scott,
move on,
you're
though,
going
we
to
have
go
to just make the point, and I don't want to stop on the discussion there, but the Energy Star program is way cheaper for manufacturers than DLC is. Just putting that out there.
That's
way cheaper.
Yeah, that's a question of how efficient is the DLC, and where's their revenue going? Okay, so DLC also, they have 75 members, right? But as the industry complains, I know NAILD is complaining, there's no manufacturers, distributors, LED lighting manufacturers or distributors that are members, right? Their input as members is I think not being taken, because their membership is offered to utility programs, right? As they call utility energy efficiency programs and regional energy efficiency organizations. And we all know, of course, there's committees where distributors and manufacturers can participate. That's a different type of accommodation compared to the membership accommodation. Go ahead, Scott. Now, I got a couple slides here, and I'm just trying to present some facts, right? I'm just trying to present it, and I'm not going to talk about it in great detail. Some of this is relevant for what I'm going to say shortly, but you could go back to those tax filings and go back to every year, back to 2011, and you could look at the revenue. This is the total revenue. And when I say total revenue, I mean everything that the DLC is getting, not just from the listing cost, certification cost, but also donations or whatever else they're getting from. I think there's some other money that they're getting, $200,000 a year from various programs. But this is the total. Look at the total, and you can compare it to the listed expense. And what's interesting is you see that back in 2011, 12, 13, 14, and 15, and 16, the expense is approximately what the revenue was, right? Not a lot of money there that's left over. And between 2011 and 2015 or 16, they're doing awesome. They're doing awesome in terms of revenue of over $12 million, right? Back in 2016.
Well, let's
And
preface
then
that. I'm going to change. They're doing awesome. I'm going to say that they're beginning to capture their nonprofit resources of the lighting industry. That's how I'll preface that.
Okay. So the point is that they're doing well through 2016. And then 2017 is interesting because there's a $2 million excess. If you look, and I double checked it, I went back, I double checked. There's $2 million extra dollars, right? The expenses are $2 million short of the revenue. And then 2018, it's $1.1 million excess. If you look at the recent years, you'll see 2022, 3, and 4, we're back and we're balanced already. We're balanced where the revenue is approximately what the expenses are. Next slide. Now, I know that some people are concerned about the expenses that are being paid by the DLC to the certification, entities, and specifically to D and R, and their numbers are listed in these documents, and you could plot their expense, the cost to fund the certification through DNR is plotted on this graph, and what it shows is that at sometimes they were capturing 50% of the revenue, right? If you look at 2016, 50% of the revenue is $5.8 million is being used for certification expenses. Next slide.
I have 8.7 million in 2019, and I got 9.7, and I got 9 million in 2018. You got it much
Yeah,
lower.
I do, and I know that we spoke yesterday. I heard what you said, and I went back, and I'm pretty confident that I had to, believe it or not, when I put these slides up, it's like I've checked 2 or 3 times, and that's just the numbers that I see on the filings. You can also look at the expenses as a percentage of the total revenue, and what you see on this slide is that between 2011 and 2016, when the total revenue was between 5.3 and 8.9, the ratio, right, the percentage goes between 12%, and it's climbing up to, in 2016, to 50%. And then since 2018, the expenses have been about 35 to 50% of the total revenue. The total revenue has varied between 9.0 and 11.8 million from 2016 to present. These are my attempt to just portray the information and the background and the facts that I'm aware of. So that's some of the background. And then, of course, we all know, go to the next slide, the May 2023.
Just so you know, I disagree with David on this. For those listening, I have them every single year from 2018 between 58 and 80% of the expenses are D plus R.
Yeah, that's fine. So I'm not carving out. It would be nice if you can look only at the LED listing program, right? I have not carved out horticulture. I've not carved out the Luna program or the network lighting controls program, and that's just because I had to put this thing together, and I didn't want to spend too much time getting down into the weeds.
That's just the LED lighting stuff. But if you add the other stuff on, my numbers will be correct.
No,
no.
I think if I were to take my total revenue and subtract it out the stuff that doesn't relate to the LED lighting, the percentages are going to go well above 50%.
Okay,
so
good.
It possibly would come into agreement with your numbers, because your numbers are saying for the money that they're getting from LED lighting certification, over 50% is going to D plus R. I think that may explain. Yeah, that may explain that issue. But
you're just talking about LED lighting. At LED lighting, yes.
Yeah. Okay. So in 2023, we have the nailed report, very detailed on the front cover, the complete and total failure of prescriptive rebates and why it's the DesignLights Consortium's fault, identifying a number of problems from their perspective with the consortium, ranging from compromising energy efficiency that's giving perverse incentives, stymieing innovation, having people spend or promote foreign manufacturing over domestic, reducing sustainability, and it goes on and on. And again, that's just background for purposes of this discussion. Next slide, Scott. So now let me, as a lawyer, jump onto the side of the LED industry, right? From the perspective of if the industry or if some of the manufacturers wanted to dismantle the certification program, right? That could be an objective of the industry. And in terms of what you should focus on, I have thoughts, right? First of all, as a factual matter, this industry has matured over the past 15 years. Why the heck do we still have this certification? That's, as a factual matter, something that I'm sure many companies in this industry can have the perspective, right? And you should be arguing that look what the EPA did with Energy Star. They sunsetted it, right?
Mm-hmm.
When you evaluate the usefulness of this type of certification, they said, no, thank you. It's not worth it. The electrons aren't worth the squeeze anymore. Mm-hmm. And of course, there's an exception for recessed downlights. I understand that. The other area to focus on, given that the DLC is a 501c3 charity, I think private industries and companies will be focused on their tax-exempt status.
Mm-hmm.
They're going to focus in on it. I think they're going to argue there's really these opaque vendor disclosures, the details of what D plus R and other vendors are doing,
Mm-hmm.
very opaque in terms of understanding. They can also focus on, and I'll get into more of this shortly, but I told you that I got the bylaws from 2017 when there was an amendment. And I
Yes.
think there are people that are going to be focused on Article 7 of that, of those bylaws.
Mm-hmm.
I think there's also going to be
Those are the
this
provisions relative to transactions of for-profit interests, right?
interested parties, interested persons, and
For-profit persons, yeah. Yeah.
yeah, and then I think some people will focus on this so-called private benefit risk. In other words, when you have a charity and there's risk that there's some private individuals or entities that are, that are gaining an advantage that's not appropriate for purposes of a 501c3 entity, people will focus on that. And then obviously the governance and the oversight, they'll argue there's failures. And that is what I think, where we're at, right? I think if I take what the Nailed has done, and if I take the perspective that if I got engaged by private industry, private lighting companies tasked with addressing the DLC's role and purpose and their important mission in the industry, there's things that you can do to dismantle it. If that was the goal of some individual that wanted to invest the time, energy, and money into doing it, right? So
Mm-hmm.
that's the industry side. Let's go to the next slide. And there's the DLC slide, of course. Next slide, Scott. And remember the issue. If the DLC wants to survive this outrage, right, what does it need to do to earn back trust and move forward on its mission? And that's one of the reasons why I agreed to come on this podcast, is to offer suggestions from the perspective of someone that I think I could sit in the middle of this thing. I could comment on the industry, and I could comment on helping the DLC, right? And this is for purposes of trying to do right to the industry and trying to move the dialogue forward. Okay, so we'll start with some background that I think is relevant, right? And just as a reminder, in 1996, the Northeast Energy Efficiency Partnerships, Inc. was formed, a bunch of utilities in the Northeast. In November of 2016, right, there was a formal name change, Efficiency Forward Inc. Okay? Mm-hmm. In 2017, for whatever reason, the board and management transitioned. Mm-hmm. And I actually have a couple slides showing this, I think, massive transition. At the same time, the corporate bylaws were amended in January 2017, and there's two provisions that I think private industry is going to focus on, and as a result, the DLC needs to focus on it because they have to address these issues and they need to know now what's coming down the road if they want to somehow earn back trust. That's some of the background. Next slide, Scott.
And no, hang on. That's Article 7. Go back, Scott, for a sec.
That's
the Article 7 amendment where they changed it to allow it to be easier for-profit interests to make money off DLC, correct?
I'm not. I'll get into what that says, and okay. I think that's going to be your characterization of it, and I'm not going there. Okay. But I don't know why they did it, but I think it's going to be looked at. Mm-hmm. Next slide. So what was interesting is the 2016 annual report. When you file taxes, your returns with the state charities and with the IRS, you have to identify officers, directors, trustees, and executives, the ODTEs, right? Mm-hmm. In 2016, 13 of them, massively populated with executive director, director of public policy, director of finance and administration, a president, a vice president, a treasurer, a clerk, and this one lists 6 board members, right? 13 people involved, all with fiduciary duties, all with obligations of loyalty. Then I told you the name changed at the end of 2016, and in 2017 there was an amendment. And now if we look at the 2017 annual report, go one more slide, Scott. What you find in the identification of the ODTEs, it was a transition year, right? This is a transition year. Remember the income, how well they were doing, even as of 2016, for whatever reason, and I don't know why, but they changed their name and the board and all the ODTEs switched. And so what you got is in 2017, they lost all but 2 of the 13, right? So 11 of the 16 of the 13 are gone. The control group, this whole group goes from 13 down to 8. And now we got 6 new ODTEs with a new name, with amended bylaws, and we only have 2 left over, and that would be 2 board members that I guess I won't identify right here, but they're circled in green. Okay, so again, this is just what I think the public and what the DLC is going to see when they start looking into this. Next slide. And I told you about the name change to Efficiency Forward. Go ahead, next slide. And back in 1996, there was a article that dealt with personal liability of officers and directors, and that's Article 9. It refers to fiduciary duty. It refers to duties of loyalty.
Duties of loyalty.
Right, that's the old.
The old.
Right, next slide. Now, again, the January 2017 bylaws, all new. And there's 2 things that I think people are going to focus on. They're going to focus on the article on indemnification. And this is indemnification of, I think, officers and directors. It's Article 9. It's a page and a half of protection for the officers and directors, paying of legal fees and things of that nature. And I'm not going to comment on it, but it's there, and someone is going to look at it. And then the Article 7 that we mentioned earlier is relating to transactions with interested persons. And go to the next slide, Scott. And here's the language. And all I want to say is that this provision makes reference to this absence of fraud standard. And it does it a couple times in connection with whether a director or officer or whether the company may enter into contracts and transact business with one or more officers or directors. And they have this absence of fraud provision. As long as there's no fraud, it's okay, right? And the contracts can't get invalidated as long as there's no fraud, okay? Next slide.
But it doesn't have the duty of loyalty. They've removed the duty of loyalty. They removed it.
It doesn't mention it, but again, I'm not going to comment on whether it changes anything, right? Because there's also
but it's going
laws,
backwards. It's going backwards. It's less transparency.
Well, I think someone will argue. I think the industry could argue that provision was outdated.
Yeah, it's an old provision. They replaced the new provision, which is more strict, with an old provision that was insufficient.
Yeah, I'm not going to get into that type of dispute, but someone may argue that it's old, that that it's obsolete with respect to referencing the absence of fraud
for 501c3s.
That current law may require full disclosure, recusal, and approval by disinterested directors with documentation. And again, I'm just trying to flag issues that I think
it makes it easier for people involved. Hang on, it makes it easier for people involved to do deals. That's the bottom line.
I'm not going to go there, Mike. It also may allow the executive director to be paid by the company. And that's the other thing. The other part of this is like the executive director is a professional getting paid, I think, having a contract with the company. And if the executive director is actually on the board of directors, you got to deal with that. So that's why I'm not going to sort of talk about like why these provisions were changed. All I could say is that I think people will focus on this absence of fraud standard that if I was hired by the industry, I would be digging into. If I was hired by the board, right, by the board of DLC, I'd be digging into and explaining why there's no problem here. There's no problem here.
But you'd be focused here.
Of what? There's no problem with the amendment in 2017 because of the way they were doing business. I mean, the DLC will take that position. They just have to be aware that someone's going to focus on it and they need to deal with it. So, anyways, next slide. So, comments about, just introductory observations, personal introductory observations.
And if you're listening to this, the slide is the DLC. Will the DLC survive industry outrage? That's the slide if you're listening to this.
And I'm going to get to comments on what the DLC should do. But before I get there, just remember, not-for-profits are unique, right? They don't have any shareholders. There's no shareholders. The DLC has 8 board. Right now, they have 8 board members, and I believe if they all were to resign, and the corporate actions are stopping, freezing. There's eventually the executive director can't write checks because there's no board that they're reporting to, and so there'll be a freeze that will kick in, weeks or months. And at that point, a court may have the authority to appoint interim directors. And the way that happens is the Massachusetts State Attorney General's responsibility for public charities would be come in, realize there's no board members, make a motion to the court to appoint interim directors to take care of this charity. And once they're appointed, then you could reconstitute the board or you could resume governance, right? Those are just comments about generally what happens with these not-for-profits and what happens if you get board members that start resigning, okay? But my advice and my comments are that the DLC, needs to stay away from focusing on all these allegations. They really need to not listen to you, Mike. They need to ignore it. They need to not get on your podcast and disprove whatever you're saying, whatever the industry is saying. And I say that just out of being a friend to the whole industry, is their focus should be to earn back trust. They need to focus on how are they going to earn back trust, from the industry. It may mean coming out and explaining anything that anyone wants to talk about with respect to some questioning activity, but focus on getting the trust back, because that's number one. Number two, my recommendation and my personal comment would be reconfigure the board to allow broader representation and promote industry trust, right? Because that's what they need. They need industry trust. And I think the very small board that's very much limited to just some participants in this industry.
Energy efficiency program consultants.
Yes. So this is my introduction to, or my introductory observations. And let's get into some specifics, Scott. If you can go to the next slide. Okay. What does the company or what does the board need to think about? As I said, either expanding the board, right? If you bring in more directors and start getting elections that are made to put and reconfigure the board to make it more balanced, right? You can do that by expanding it and then sequentially reconfiguring it to get more members. And this is something that I think the DLC should consider to get broader spectrum of stakeholders across the industry. Include the manufacturers, include the distributors. Fine, include.
Can you imagine if Devin Wall was a board member of DLC, Greg?
Shake it up a little bit.
Ah!
So they don't get paid, and it's hard to find people that are willing to, I think, not get paid and jump
Unless you're
into
unless you're
this.
an energy efficiency program consultant, then you love serving on the DLC board. It's like
Okay.
having a ticket to ride on your resume.
Okay. So, and that's going to be a challenge to the company to, I think, pull in people that are willing to get into this dispute and this problem. This is really, a crisis for the board. The board is in the middle of a crisis, and I really can't believe that they're I don't know how long these people are going to be willing to stay in the middle of this thing. So, in terms of getting people in there, what should the board be focused on? Think about sunsetting the certification, right? Follow the lead of the EPA.
Follow the letter
Think
of the
about it.
nail from Devin Wall and Matt Hansen that said 2030 we're out. We're keeping everything the same. Just like we said,
Okay.
nicey nice in the sandbox, David. Nicey nice. We tried.
There may be others that say no, Michael. There's other manufacturers that may have a different perspective. I don't know, but the DOE decided that they're not going to continue the certification,
And
because
the
it didn't
Energy
make much
Star was way cheaper than DLC. Let's just keep reminding everybody of that. Manufacturers loved Energy Star, David. They hate DLC.
Yeah. Okay.
Yeah.
So the board should also consider, this is based on the nailed comments about the appropriateness of spending 3 to 5.8 million yearly, right? On what I call alleged spreadsheet services. That's your phrase. It's not my phrase.
So good, eh?
But keep in mind, the board shouldn't be focused on disproving that they're not just spreadsheet services. They shouldn't be focused on that. What they should be focused on is explaining why this all makes sense. This all is okay.
Come on, get a grip on lighting and tell us.
Focus on. Okay, and there was a suggestion by Randy Reed from his article on Wednesday evening about bringing the services in-house. Go hire a few people to take care of this. Right?
Yeah, it won't cost $9 million in 2018.
But as I said,
David's numbers are wrong, folks. David's numbers are wrong.
Okay.
We can fight about it after.
Good. And as I said in my disclaimer, right? Don't rely on anything I say.
Me neither.
Right? Don't rely. Okay. There should also be some work done, legal research, looking at those bylaws. And the board should put in some effort to just get comfortable that the amendments in 2017 conform to the best practices for not-for-profits.
Yeah, maybe think about it for a bit. Think about it for a bit. Think it through whether or not you want to really make it an older standard rather than the most updated one. Maybe you want to go for best practices, David.
So that's your comment, and I'm not adopting it, but
I'm right.
It's fine. Yeah. And with respect to best practices, normally any insider deals, unless they're transparent, unless they're arm's length, and unless they're approved by disinterested board members, are problematic. But like I said, the salary for an executive director is as long as it's transparent, as long as it's arm's length, and as long as it's approved, right? You're not enriching one particular executive director. You can have an insider transaction, right? But the point is also make sure all of these contracts are all transparent, right?
Might be a good
idea. I'm sure the industry. We just lost.
Don't worry about
Greg.
He's got to come back in. Don't worry, he's frozen.
I'm sure the industry is interested in the contract with D+R.
Oh yeah.
And I think that with respect to that contract, I think the board is going to have to consider just opening up on why, from the board's perspective, it's all fine, it's appropriate, it may be expensive, And it may be as simple as if you can show the D plus R profit is 5%, Michael.
I'm sure he can show that.
This is all. It's all going to blow by. If the D plus R profit is 90%, this is where it's going to be a problem, and this is where the board needs to immediately try to get the right people in there to try to figure out how to get through this crisis.
What Nailed asked D plus R was how many people he had working on the file. That's what we asked, and he didn't respond.
Yeah. Okay, so those are ideas for survival. Next slide, Scott. Yeah, there's always the question of, can an industry consortium be a public charity for tax purposes?
Yeah, it's a good question, isn't it?
And
what he's saying is, can a consortium of for-profit interests manage an independent 501c3 charitable organization while profiting from the very work the charity does? That's what he's saying, right?
Well, that's your characterization of what I said. But
okay, you're a lawyer.
The answer is that there's many industry consortiums, these trade groups and these standard-setting bodies that are not public charities under 501c3 because their primary purpose benefits a defined group of for-profit members, not the public at large, right? And that's one answer. And they usually qualify under it's a different provision. It's 501c6 for trade associations, for chambers of commerce, and for business leagues. Okay?
Like nailed.
Yes. Next slide, Scott. Okay. And one learning point here.
Hang on. I just want to say this, that you and I discussed this. A lot of this information here is from our accreditation agency advisory committee notes, David. Just make sure you preface that. I sent this to you yesterday from our notes, Devin Wall's work. Just saying.
I know that Nailed says, look at the UL. Look at how UL is dealing with a very similar issue. And my point is that the board of DLC should also look very closely because the Underwriter Laboratory has a nonprofit parent, 501c. They're focused on science research, standards development, and public education. They own the UL brand. They govern the mission. They use dividends from a for-profit subsidiary to fund that research. So they formed a separate subsidiary that is for-profit called UL Solutions. That's the subsidiary that does the testing, the inspection, the certification, and they do it worldwide. They compete commercially with ETL, TUV, and CSA. So that certification for-profit business is pushed down into a sub. Dividends are paid to the charitable parent in furtherance of the parent's mission, which is for research, standards development, and education, right? And so they've separated out the for-profit certification business from the charity
But
business.
David, this is Devin Wall's work on our creation agency advising me. I'm just making sure you let all the listeners know this is from Devin Wall.
I hear you, and as I indicated on a slide at the very beginning, I read a lot of stuff.
But hang on, this is what's happening here is UL has a standard that Devin put in the all our reports, UL 1598, and this governs the valuable metrics, Greg, of a light fixture. Can the mechanical housing, is it strong enough to hold the driver in the array? Can it be hung from the ceiling? What's the voltage of the fixture? What's the max voltage? What's the wattage? What's the lumens? I don't know if it's lumens, but Devin had it all in his report because when we did our accreditation agency advisory committee, Greg, we looked at UL, we looked at Intertech, we looked at all this stuff, and what we found was that the certification piece was for profit and competitive, and Intertech, ETL, and all the other certifications compete with each other to certify fixtures to the UL 1598 standard. And so UL, its separate division, competes with other certification services for manufacturers and customers. And so David loved that work that we did. So carry on, David. Sorry, just want to make sure that Devin gets credit for
Yeah,
his work.
and my comment is that the board of DLC should consider, again, they got to get back trust. They got to get the public and the industry to trust them. And maybe if they're going to keep certification, push it down into a for-profit sub and try to make as much use of how the underwriters lab set up their system to deal with this. It also allows, right? Remember the horticulture lighting,
Sure.
remember Luna, remember network lighting controls. It's like everything's all intermixed right now, and that's one of the issues
And you
with
can't
trying
be
to
the
figure out.
certifier and the standards person. You're either a standards creator or you're a for-profit certifier. And right now, DLC controls both, and it's a gate to the utility rebate market.
Yep, that's what the industry is saying, and that's what the
You're
board.
such a lawyer.
That's what the board. That's what the board of the DLC should focus on. That complaint, and they really need to address it.
Yeah, they really need to address that
maybe,
big time.
But again, their perspective is they took input on these standards. Everyone had their say looked at. Everyone had an opportunity to comment, and they're doing what the stakeholders want.
Yeah, sure.
That's going to be their perspective on it. Okay, let's go to the next slide. I have two more. I'm not going to spend much time on these last two, and I'm going to wrap up. But as I said, the board needs to focus on the trust issue. The board needs to anticipate what the complaints are. The board needs to get ahead of these things and address them, before, they're forced to do it through some process, initiated by a manufacturer or a distributor. So these are the red flags that the attorney general and others are going to look at. They're going to ask, does this thing operate like a fee-based industry consortium and not a public charity?
It does.
How does the board address that? How are they going to deal with that? And how are they going to get trust back to show that they're actually, in fact, a public charity as opposed to a fee-based industry consortium? Number two, the people are going to complain about the heavy contractor spend.
D plus R.
Some people will say zero detail or oversight disclosure. The board has to deal with it. You got to figure out how you're going to deal with it, how you're going to get past, the uproar. The board governance and the internal controls, people are going to argue they're insufficient. And again, instead of arguing, oh, they're sufficient, they should be figuring out, how do we get the trust back? How are we going to move forward? Don't get pulled down into the weeds of trying to, on a one-by-one basis, dispel and address, very individual complaints. And that's why they need to have guidance. They need to have someone who can conduct this, response. And so they can conduct and figure out what are the different angles of how they have to build back trust. And it's going to require someone that's familiar with the industry, familiar with the legal process, familiar with the biggest problem, of course, is the DOE sunsetted Energy Star as a factual matter not needed. You need an advisor to actually address, if you're going to keep that certification process, why it makes sense to maintain it. And you need to address all of this in a global manner, in order to move forward, I think, in my personal opinion. The other red flags about private benefits to industry participants, this is your issue with the energy utilities getting benefits, and then the lack of transparency.
No, what we're talking about is people
audits.
involved with DLC that actually sell utility rebate program consulting to utilities.
Yeah.
That's a major red flag, David.
Yeah. So I do have on the last bullet point this lack of transparency around audits and then independent review. There is an independent auditor's report that's filed every year, right? And that's part of the 80 documents that are downloaded. So there is some type of independent auditor review, but I'm sure people are want to know more details about the finances. And let's go to the last slide before the takeaway slide. The charity the board, they operate under 501c3, and the government and government tax framework, looks and will determine and make sure that they pass this operational test, that the company is organized and operated exclusively for exempt purposes, charitable purposes, educational or scientific, right? And there's this operational test that when you look at the finances and you look at their whole way of doing their charity, that it's operationally, not just what the bylaws say, and not just what the missions
Yeah,
are.
but the actual
but
outcomes.
Are they actually
the outcomes.
Are they actually operating in a way that is going to pass?
Mm-hmm.
And this is where they balance the public versus private interests, and they'll look at what are the private interests as a result of the way they do business. And again, the board needs to figure out how to address these complaints. They need to get ahead of these issues if they're going to move forward, in my personal opinion. And if I was advising the board, if I was engaged by the board to help them in this crisis, and look at everything from the need for the DLC certification to the need to have an external consultant to take care of a spreadsheet or to do the certification services, or to have 6.0 go forward. 6.0 for SSL,
Yeah.
right? Okay, last slide, just the takeaways, right? The DLC's tax and governance status raise legal and policy questions, of course. The LED industry wants to push for reform or for reclassification, and both sides should consider some collaborative reform, before there is government regulator or IRS involvement, right? And so that is, the summary, 30 slides in 1 hour.
You did it. You did it.
I think I was okay on this.
You did
And
good.
I'm not sure. And I think I'll thank you then for inviting me on this podcast, as opposed to asking for an apology, because I think we did okay. I think we did okay. I think I stayed grounded, and I didn't lash out to anyone or on any side.
And
Right?
that's fair, and that's what we appreciate, and that's really what we want. But there hasn't been the open feedback and open discussion, and I don't know why. Like if it's, Mike, we want it on Get a Grip, but talk to somebody in the industry. Just be open and be honest with what you've done or what you guys do and how it works, so that we understand it. And maybe they have a great explanation for it all, and we just say,
now,
thank you.
Let me tell you why.
Move on.
Let me. I have a comment on why.
Okay.
It's complicated because
Sure.
there's a lot of issues that relate to the factual issue of, is certification necessary, right? What about the finances? What is the cost of the certification process, and why are these expenses justified, right? Also, what about the charitable tax provisions? How are you staying in compliance with the charitable tax issues? And what about the lack of trust? And you can't just pull one person from the DLC, put them on a show, and answer all those questions.
This is the only show that would happen on. If they came on this show, and they were all straight up, and just like Greg says, tell it to us. If they came on here, Tina's already been on here. Hundreds of people have come on this show. We're nice guys. We just ask tough questions.
Yeah,
and if you answer them here, you can clear your name. You don't need to pay David Radulescu. I would say just come on this show and you won't need it. But if you don't come on this show, you're probably going to need David Radulescu.
I would advise the company, the board, not to send someone on this show. And I say that because
thank you for the compliment.
There's multiple facets to this problem. And one person is not going to be able to address all five.
David Steiner, me, and you. Let's go.
Now, they need to engage. I'm going to say they need to engage probably a lawyer to get around all these issues and have the lawyer go on your show representing the DLC and explaining how on all these issues, right, there's no real problem.
Good
right?
luck with that.
These are just unjustified complaints
Good
and
luck.
unjustified focus. Okay?
David Radulescu. You can find him at radip.com. You're going to see his phone number up there, David Radulescu, PhD. He's a friend of the show. Every time we need legal opinions, we call David because he knows the lighting industry. And you know what? Like I said earlier in the show, when we were talking initially on the phone back and forth and emailing, there was a constant focus also on what's best for the industry here. What's the best thing to happen of all this chaos that Greg created? This Greg guy, Greg Eric is a wild man. All this chaos that he created, what's the best thing for the industry? And that's what I really, my heart warmed to David again, and we were thinking about it. And sometimes you need a lawyer. So you can go to radip.com, and if you have light bulbs in the warehouse, it's naild.org. Thanks for listening.
Thank you.